Okay, so I'm here with Sanford Bernardo, and he is president of the Northeast Assisted Fertility Group and a lawyer who specializes in third-party reproduction law. And we're just going to go over the topic of surrogacy in the law. And he's just going to explain from a legal standpoint how surrogacy works from start to finish. Hi, Sanford.
Oh, hi, Kathy.
Hey. So just tell us how long you've been doing this, working with adoption and third-party reproduction law.
Well, I've been a lawyer in this field for 27 years now, and my practice is focused specifically on third-party law. Now, it used to be adoption. Now it's mostly third-party surrogacy, egg donor work. That's all I do.
Okay. So first I want to ask, and this is confusing to a lot of people, is surrogacy even legal? I mean, in the United States, and maybe talk a little bit about in other countries to the extent that you know, is it legal in every state? And I mean, you can't really contract a woman to have a child for you. So why don't you just give us the specific aspects of what makes surrogacy legal?
Sure. Well, you're right about that, Kathy. You can't hire a woman to have a baby for you and then put that terminology or that phraseology into a contract. But you can have somebody with her time and effort have a child for you, which is not genetically hers. And that's what a gestational carrier situation is all about. There are laws that govern surrogacy, especially here in the US. There are laws that prohibit surrogacy in much of the rest of the world, which is why people look to us not only for our great medical care, but for the legal protections that we have here. So most of Europe looks at IVF and fertility treatment and third-party reproduction in a wholly different way than we do here. And when you're looking at the US, surrogacy is governed by state law, not by federal law. So every state has its own viewpoint on surrogacy. Many states have no law at all, meaning nothing written down, statutory language, no case law, decided opinions, judicial opinions to rely upon for precedent, for people to know what to do, what's allowed, what's not allowed. Some states do have statutory law. Illinois, for instance, has a codification of the law, which is reliable. New York now does, which is somewhat more onerous, let's say. And then there are other states which are more established locations like Massachusetts and California. And there's case law. There are decisions that judges and lawyers and participants rely upon in those states. So when it comes to deciding where to do your surrogacy, meaning which state the carrier will be living in and delivering in, which is where the operative law comes from, we do have to look at the landscape of that state, how it is now, and how it may be in the future, because there are political changes and other changes that have made surrogacy more closed and more open in various locations.
Mm-hmm. So what states do you generally work in?
Well, the decision as a program, as a lawyer, I'll help people in states where I practice, which would be New York and Massachusetts. But as a program, we like to work in states where we have relationships, where things have done in the past, where we've been able to do things well, and we expect that will continue in the future, where we know lawyers and we have relationships with the Department of Health and other entities. Those states, as of right now, primarily consist of Pennsylvania, Massachusetts, Texas, Georgia, Ohio, a number of New England states, Massachusetts, as I said, Connecticut, Vermont, Maine, and New Hampshire. New Jersey is another state where we work. Maryland from time to time is another state where we work. It's possible to work in Kentucky. It's possible to work in Tennessee in certain circumstances. There are certain states that have their own specific rules about who can engage in a surrogacy, whether or not you can use donor material, whether it has to be a married couple. So we take a look at things like that. But there are a handful of states where we have relationships with carriers too. We want to work in locations where we know the OB practices. All that stuff helps create a good and solid relationship that is less likely to have issues or problems. And we have lawyers in each of those states that we know well and have worked with over the years too.
So the choice of law depends on where the carrier or surrogate lives, and she typically delivers in her home state with her own doctor. So that's where the law pertains.
That is
It's
that is
not
correct.
it's not where the intended parents live, and it's not where the clinic is, because often the surrogates have the embryo transfer in another state and then go back home and then have all their prenatal care and delivery in their home state.
The
Generally.
clinic is not where any of the parentage work comes from, but the clinic needs to be in a state that is not unable to perform surrogacies or commercial surrogacies. That
Right.
much we have to know, which is why
Okay.
we couldn't do it in New York for many years. So yeah, the state where the carrier lives, that's where all the legal work originates from. That's where you need the lawyers. That's where the contract is based.
Right. So even if it's an international couple and they come from a place where surrogacy is not allowed, it just really depends on where the carrier lives. People need to understand that.
Many people have the misconception of thinking that because they live in a location of the world or a state in the US, like Michigan, for instance, which has restrictive laws related to surrogacy, that they can't do this. And that's false. They can't do this where they live, but what they can do is work in another state that has favorable laws and then have all the legal work come from that state and take the baby home to where they live.
Right. And a lot of people don't realize well, even in the best of circumstances, you don't live in the same state that your carrier is in. Almost all carriers, even if they're within driving distance, can be over state lines, and that's totally normal. It's a normal, so it's not really out of the ordinary to work with a carrier from another state. You may live in a state where surrogacy is not allowed, but she's in a state where it is, and there's no problem.